The alleged bribery offenses of Airbus in respect of Ghana was investigated by the SFO in the United Kingdom, while the DOJ in America investigated violations by Airbus of parts of the US ITAR in the context of the alleged bribery offenses in relation to Ghana. Therefore, as I said, the judicial decisions of the United Kingdom and the United States affected Ghana. Consequently, investigations carried out by the SFO and DOJ and the decisions of the two courts bear on the investigation by the OSP and thus require recourse and in some detail. Bear with me. This is important. First, the United Kingdom. It is well known that on 31 January 2020, the President of the Queen's Bench Division, the Right Honourable Dame Victoria Sharp, sitting in the Crown Court at Southwark, delivered a final declaration and order in respect of a deferred prosecution agreement, DPA, between the SFO and Airbus in the case of Director of the Serious Fraud Office against Airbus. This was based on investigation conducted by the SFO in respect of Malaysia, Sri Lanka, Taiwan, and Ghana, which was held to demonstrate that in order to increase sales, persons who performed services for and on behalf of Airbus offered, promised, or gave financial advantages to others intending to obtain or retain business, or an advantage in the conduct of business for Airbus, and that those financial advantages were intended to reward such improper performance, and further that Airbus did not prevent or have in place at the material times adequate procedures designed to prevent those persons associated with Airbus from carrying out such conduct. In respect of Ghana, Airbus was charged with the offense of failure of a commercial organization to prevent bribery, contrary to Section 7 of the Bribery Act 2010 of the UK. The particulars of offense stated that between 1 July 2011 and 1 June 2015, Airbus failed to prevent persons associated with Airbus from bribing others concerned with the purchase of military transport aircraft by the government of Ghana, where the said bribery was intended to obtain or retain business or advantage in the conduct of business for Airbus. The accompanying statement of facts summarized by the SFO's position is that between 2009 and 2015, an Airbus defense company engaged intermediary 5, who was stated as having no experience in the aviation sector, a national of the UK but born in Ghana, and a close relative of a high-ranking elected Ghanaian government official described as Government Official 1, as its business partner in respect of the proposed sale of 3 aircraft to the government of Ghana. A number of Airbus employees knew that Intermediary 5, who was a close relative of Government Official 1, a key decision maker in respect of the sales. A number of Airbus employees made or promised success-based commission payments of approximately 5 million euros to Intermediary 5. False documentation were then created by or with the agreement of Airbus employees in order to support and disguise these payments. The payments were intended to induce or reward improper favor by Government Official 1 toward Airbus. Intermediary 5 was assisted in his work for Airbus by 2 other nationals of the UK, Intermediary 6, a good friend of Intermediary 5, and a UK television actor and film director, and Intermediary 7, a former UK television actor. Contact between Airbus and the government of Ghana about aircraft sales began in June 2009 following an expression of interest by the government of Ghana. By August 2009, employee 15 reported that he was in contact with Government Official 1 and his team. On 7 December 2009, Intermediaries 5 and 6 incorporated a company, Company D, in Ghana for this purpose. A company of the same name was incorporated in the UK in February 2010. Company D was a corporate vehicle through which Intermediary 5 and his associates provided services to Airbus. In December 2010, Airbus employee 16 was made aware that Intermediaries 5 and 6 were or had recently been working for Government Official 1 and or the government of Ghana. The Airbus campaigns in Ghana culminated in the sale of 3 C-295 military transport aircraft by Airbus to the government of Ghana. In respect of the first campaign for the aircraft, Airbus paid 3.9 million euros to a third-party company, Intermediary 8, between March 2012 and February 2014. Intermediary 8, in turn, paid 3.8 million euros to Company D. In respect of the second campaign for the sale of one C295, Intermediary 5, or Company D, were promised approximately 1.6 million euros. The promised amount was not paid. From 2009, Intermediary 5 and its associates worked on the sales to the government of Ghana without any written consultant agreement. This included liaison with Government Official 1 regarding the potential Airbus 295 sale. Intermediaries 5 and 6 submitted a report to Airbus which documented a January 2011 meeting in London attended by themselves, Government Official 1, and Airbus, at which the C295 aircraft was agreed upon as the most suitable aircraft for the needs of the government of Ghana. By April 2011, Airbus employee 16 reported to his colleagues that the deal was close to being finalized. He then asked intermediaries 5 and 6 to transmit a letter to Government Official 1 and explain a possible delay. He also asked them to secure meetings with the Ghanaian Ministry of Defense and Ministry of Finance. On 18 May 2011, Intermediary 6 emailed Airbus employee 16, stating that Government Official 1 had taken the relevant financials to the Minister of Finance and that intermediaries 5 and 6 were planning to go to Ghana within the next couple of weeks so they could oversee the project personally. Company D then submitted a formal business partner application to Airbus in May 2011. On 8 July 2011, Intermediary 6 sent Airbus employee 15 a company update. He reported that he had just returned from Ghana, quote, having had very productive meetings with all parties, including Government Official 1, the Ministry of Defense, and Minister of Finance, end quote. The email stated that the C295 sale was agreed at all levels and was expected to clear Parliament by 14 July 2011, and that Government Official 1 had expressed an interest in buying 2 more C295s. On 3 August 2011, Airbus Spanish Defense subsidiary and the Government of Ghana signed a purchase agreement for the sale of the C-29 aircraft. The following day, Airbus employee 17 declared to the Spanish Export Credit Agency that no more than 3 million euros would be paid to business partners in connection with this contract. Although no payment had actually been made yet, this figure broadly reflected a 5% commission on the sale of the aircraft. The same document also declared compliance with the Organization for Economic Cooperation and Development (OECD) Convention on combating bribery of foreign public officials in international business transactions. Following the May 2011 business partner application, Airbus commissioned an external due diligence report on Company D. The resulting report, dated 30 September 2011, identified Intermediary 5 as a shareholder of Company D and the possibility that he was a close relative of Government Official 1. The source of the information was a UK newspaper article quoting Intermediary 6. The Airbus external due diligence report raised concerns that there was a risk of non-conformity with the OECD convention. Faced with this concern and a stated fear that a failure of the Company D application portended the prevention of Airbus from doing business in Ghana for a number of years, relevant Airbus employees agreed to and did substitute Company D with a Spanish company, Intermediary 8, which was a pre-existing Airbus business partner, by deliberately circumventing the proper compliance process by falsely representing that the work in respect of the first campaign had been done by Intermediary 8, which could then in turn make the money available to Intermediary 5 and others. On 9th March 2012, Airbus Employee 1 and Airbus Employee 22 approved the Intermediary 8 business partner application for the first campaign of the sale of the C295 military aircraft to Ghana. A consultant agreement between Intermediary 8 and Airbus was dated 20 March 2012 and with an effective date of 1 January 2010. Agreement provided for a percentage commission fee of the net total amount received by Airbus by virtue of any commercial contract with the government of Ghana for the C295 aircraft. As indicated earlier, between March 2012 and February 2014, Airbus paid 3.9 million euros to Intermediary 8, which in turn paid 3.8 million euros to Company D and retained about 60,000 euros. By the time of the second campaign, the March 2012 Intermediary 8 consultant agreement had expired. A request on 24 February 2014 by Airbus employee 21 and Airbus employee 15 for the extension of the expired agreement was refused on 9 March 2014 by Airbus employee 20, who advised that a new agreement would have to be signed. Extensive discussions via email were held by relevant Airbus employees and Intermediary 5 on the urgency to carry the deal forward since it had stalled. Government Official 1 was blind copied in some of the emails from the relevant Airbus employees to Intermediary 5. Intermediary 5 assured Airbus employee 16 on 14 October 2014 that he has spoken with Government Official 1, who had expressed that there will be movement on the transaction. A draft business partner application in the name of Intermediary 8 was created in February 2015, and a request for payment presented to the Airbus Liquidation Committee in April 2015. However, the Liquidation Committee requested further due diligence before payments could be concluded. Intermediary 8 declined to participate in an interview and accordingly failed the due diligence exercise. Airbus did not enter into a written contract or make any commission payments in respect of the second campaign. Correspondence from Intermediary 5 to Airbus claimed that he was owed 1.6 million euros. Airbus disputed the claim by Intermediary 5. No proceedings have been instituted by Intermediary 5 or Company D. The UK authorities and Airbus agreed on the foregoing as the established facts. In brief, Airbus failed to prevent persons associated with it from bribing others concerned with the purchase of military transport aircraft by the government of Ghana, where the said bribery was intended to obtain or retain business or advantage in the conduct of business for Airbus, and that a number of Airbus employees agreed to deliberately circumvent the proper compliance process by falsely representing that the work in the first campaign had been done by Intermediary 8, which could in turn make the money available to Intermediary 5 and others. Further, the sum paid to Intermediary 8 by Airbus and then by Intermediary 8 to Intermediary 5 exceed, in the latter case, by about 850,000 euros. The agreed commission amount set out in the Declaration of Compliance by Airbus to the Spanish Export Credit Agency. Now to the United States. It is also well known that on 31 January 2020, the United States District Court for the District of Columbia reached similar conclusions by way of a deferred prosecution agreement, DPA, or a consent agreement in the case of United States of America versus Airbus. In relation to Ghana, the DPA posited that Airbus willfully concealed its political contributions, fees, and commissions paid to business partners in conjunction with the sale or transfer of defense articles and defense services in violation of the U.S. ITAR, which I referred to earlier. This was because certain ITAR-controlled defense articles from the U.S. suppliers were components of the C-29 aircraft, which was being manufactured for Ghana. These components were exported from the U.S. to Spain for the manufacture of the C-295 for onward transmission to Ghana, and that Airbus repeatedly filed re-export license applications at the U.S. authorities relating to the two C-95s that included false or incomplete certifications related to the U.S. ITAR. The DPA stated that between 2009 and 2016, Individual 1, a citizen of Ghana, was a high-ranking elected government official in Ghana during the relevant ITAR time period. And that beginning in on around 2009, a few months after Individual 1 took office, Individual 1 was in direct and repeated contact with senior Airbus executives from both the Defense and Space Division and SMO International, one of Airbus entities responsible for reviewing the use of business partners and payments to third parties, about Airbus sales campaigns. Individual 1 was influential in having the government of Ghana approve aircraft purchases, and Individual 1 contacted Airbus senior executives during the government approval process. In 2011, during Individual 1's time in office, the Ghanaian Parliament approved the purchase of 2 C-295 aircraft. In connection with the sales to Ghana, beginning on or about 1 January 2009, the Defense and Space Division's Spanish subsidiary contracted with Individual One's brother, Consultant 4, a citizen of Ghana and the UK, to act as a third-party consultant for Airbus during the C-295 sales campaigns. Airbus purposefully sought to engage Consultant 4 due to his closeness to Individual 1, and Airbus management consulted Consultant 4 in their communications with Individual 1. Airbus used Consultant 4 as a conduit for messages intended for Individual 1, and Consultant 4 traded on his access to Individual 1. Consultant 5, a citizen of the UK, worked in conjunction with Consultant 4 to assist in the sale. Consultant 4 and Consultant 5 initially were engaged by Airbus without any written business partner agreement and without Airbus completing due diligence. Airbus initially agreed to pay Consultant 4 through a company owned by Consultant 4 and Consultant 5 in excess of 3.5 million euros. Airbus worked with Consultant 4 and Consultant 5 for 2 years before submitting a business partner application to Airbus compliance staff. In October 2011, Airbus compliance staff rejected the proposed contract between Airbus and Consultant 4 and Consultant 5's company because Consultant 4 had a familial relationship to Individual 1. Specifically, Airbus compliance staff found that the shareholders of this company are so close to the decision makers. Thereafter, due to the scrutiny of using Consultant 4 as a business partner, senior leadership in SMO International and the Defense and Space Division of Airbus concocted a plan to deliberately circumvent Airbus compliance rules. Specifically, the Airbus executives proposed to pay Consultant 4 via Organization 1, a Spanish-based third-party business partner of Airbus previously used on other Defense and Space Division campaigns. Organization 1 was already in good standing with SMO International. However, it had no prior affiliation with Consultant 4 or Consultant 5. Airbus used Organization 1 solely as a pass-through entity to obscure the involvement of Consultant 4 in sales transactions. Organization 1 did not undertake any third-party business activity in Ghana in connection with the 2011 campaign to sell 2 C-295s to the government of Ghana. Under this scheme, on 20 March 2012, Airbus entered into a contract with Organization 1 to provide business partner services to the C-295 Ghana campaign. Although the agreement was signed on 20 March 2021, it stated that the effective date for the contract was 1 January 2010. The agreement was signed by Airbus Defense and Space Management, and it noted that Organization 1's operational address was in Ghana, despite the fact that Organization 1 was a Spanish company operating in Spain. Under the agreement, Organization 1 will be provided a success fee for the C-295 aircraft sale. The success fee was calculated to be approximately 3 million euros, a similar amount that had been promised to Consultant 4, which was 3.5 million euros. Pursuant to the agreement, between March 2012 and February 2014, Airbus paid in excess of 3.5 million euros to Organization 1 in Spain. The payments were authorized by SMO International. Thereafter, Organization 1 transferred money to the account of the company owned by Consultant 4 and Consultant 5. Organization 1 took a percentage of the money prior to the transfer. In total, the company owned by Consultant 4 and Consultant 5 was paid in excess of 1.8 million euros in May 2012, relating to the 2011 sale of 2 C-295s to Ghana. Consultant 4 later claimed 71,000 euros was still owed to him related to this sale. In February 2014, Airbus management at SMO International and the Defense and Space Division sought to extend Airbus's contract with Organization 1 related to a subsequent campaign to sell C-295 aircraft to Ghana. Airbus compliance staff rejected the extension request and required that a new contract be signed. In March 2015, a request was submitted for Organization 1 to be paid 1.6 million euros for the sale of 1 C-295 aircraft to Ghana. Consultant 4 Consultant 4 subsequently demanded from both Airbus and Organization 1 payment of 1.6 million euros in connection with the 2015 C295 sale. Additionally, on or about 28 March 2012, Airbus made political contributions in the amount of 62,000 euros to a Spanish foundation related to agricultural development in Ghana. This contribution was not initially disclosed to the US authorities. Airbus subsequently disclosed it out of abundance of caution. No direct link yet has been established between those political contributions and the relevant C295 sales has been identified to date. Airbus admitted, accepted, and acknowledged that it was responsible under US law for the acts of its directors, employees, and agents as charged in the DPA. And that the allegations described in the DPA are true and accurate. Airbus also accepted that the facts were established beyond reasonable doubt and that the facts took place during the relevant time frame.